Earlier today at 9:33 a.m. Eastern Time, my office was formally notified that Melania Trump's attorneys rejected a federal cooperation agreement. That agreement would have allowed her testimony to significantly reduce Ivanka Trump's potential sentence in an ongoing federal fraud prosecution. Melania declined. Just 17 minutes after that decision, evidence began arriving almost immediately. A sworn Secret Service witness statement, a series of private text messages, and a social media post that was later deleted. All of it captured the defendant's reaction after being informed that Melania would not assist in keeping his daughter out of prison. This should not be brushed aside as family tension. From a legal perspective, what occurred next is critical. Federal prosecutors routinely offer cooperation agreements to witnesses with first-hand knowledge. Melania Trump was not charged. She was a key witness. Her testimony could have reduced Ivanka Trump's sentencing exposure from 11 to 19 years down to approximately 6 to 10 years. That difference determines whether Ivanka's youngest child finishes elementary school or high school while their mother is incarcerated. Based on evidence obtained this morning, the defendant reacted with documented anger, threats, and pressure tactics. Behavior prosecutors legally describe as consciousness of guilt. The investigation timeline explains why this refusal mattered so much. On April 15, 2024, I authorized the first subpoena for Melania Trump's financial records connected to Trump Organization transactions. Her name appeared as a signatory on accounts tied to fraudulent loan applications, with her signature linked to 17 transactions between 2018 and 2022. By July 2024, Melania Trump had been interviewed twice under subpoena. She was not a target, she was a witness with direct knowledge of financial dealings between the defendant and Ivanka Trump. During those sessions, we learned that Melania was physically present at meetings where the defendant instructed Ivanka to falsify loan documents. She heard the discussions and observed documents being altered. On October 3, 2024, Ivanka Trump was charged with 3 counts of bank fraud, 2 counts of tax fraud, and 1 count of conspiracy. The case was strong, but Melania's testimony would have made it virtually unassailable. On December 9, 2024, my office sent a formal cooperation letter to Melania's attorneys. The terms were clear. Testify truthfully about 3 specific financial transactions, and the government would recommend a downward departure in Ivanka's sentencing. Her legal team requested multiple extensions. Both the January and February deadlines passed. This morning, at 9:33 a.m., we received a formal refusal. The letter was brief and definitive. Melania Trump declined the government's cooperation offer. No explanation, no counter-proposal. Claims of spousal privilege do not apply to business transactions conducted in the presence of others. This refusal was not rooted in privilege. It was a deliberate choice. Melania's testimony could have addressed 3 key transactions. The first involved a May 17, 2019 meeting at Mar-a-Lago concerning a $47 million Deutsche Bank loan application. An accountant testified that the defendant instructed Ivanka to inflate asset valuations using outdated appraisals. Melania was seated at the table. Her testimony would have corroborated that account. The second involved text messages exchanged in August 2020 during an IRS audit. In one message, Melania advised Ivanka to use the Cyprus structure like we discussed with your father, referencing methods to conceal beneficial ownership. Melania could have explained what that structure meant and what had been discussed. The third involved offshore accounts. Bank records show Melania was listed as an authorized user on accounts in Cyprus and the Cayman Islands, holding approximately $18.44 million. Her testimony could have clarified ownership, purpose, and control. While documentary evidence already exists, emails, bank records, and accountant testimony, corroboration from a witness who was present removes reasonable doubt. The defendant's reaction to Melania's refusal further supports that conclusion. At 10:15 a.m., a Secret Service agent submitted a sworn statement describing a phone call between the defendant and his attorney. The agent overheard shouting, escalating profanity, and witnessed the defendant throw his phone against a wall. At 11:13 a.m., the defendant texted his son Eric, instructing him to pressure Melania, emphasizing that there are consequences. That conduct constitutes witness intimidation. At 11:27 a.m., the defendant published a threatening social media post. It was deleted 17 minutes later, but screenshots were preserved. In court, this sequence is known as consciousness of guilt, responding with anger and threats rather than denial. Ivanka Trump now faces 3 counts of bank fraud, 2 counts of tax fraud, and 1 count of conspiracy. Under federal sentencing guidelines, her total exposure is 11 to 19 years, with no parole. With cooperation, that range could have dropped to 6 to 10 years. Without it, prosecutors will recommend the upper end. This case also fits a broader pattern. Ivanka Trump is the 3rd Trump family member charged in financial crimes linked to the Trump Organization. Each case involves falsified records, offshore accounts, hidden ownership, and coordinated family participation. In legal terms, this constitutes a continuing criminal enterprise. The trial is scheduled to begin June 9, 2026. Documents, witnesses, bank records, emails, and expert testimony will be presented. Even without Melania's testimony, the evidence is overwhelming. Paper doesn't lie, wire transfers don't lie. And the law applies equally to everyone. No one is above it.